Hello, everyone. Thanks for joining us today. Just to do a very brief introduction, I'm Adele Clapp. I'm a senior tax manager at Bishop Fleming, specialising in international and employment taxes. Anyone who has approached me or any of our international specialists at Bishop Fleming will be aware that we are part of the Kreston network. I'm therefore delighted to be joined today by Elena Ramirez, who is a partner at Kreston Iberaudit, a partner firm based in Spain. Elena, I'll pass over to you so you can introduce yourself properly and actually say the name of your firm properly as well.
Hello, everyone. Well, first of all, I would like to thank Adele and Emily from Bishop Fleming to organize this interview. I think it gives us the opportunity to get to know better personally and professionally, and especially to provide some initial advice and guidelines regarding Spanish labor and tax issues that could affect to UK companies that have employees working in Spain. As Adele has said, I'm a partner of Kreston Iberaudit. I'm a tax partner, and I'm also the director of the international office, and also a member of the board of Kreston Global. Let me give you a brief about Kreston Iberaudit, who we are. We are a multidisciplinary firm with 15 offices. We have presence in Spain, Portugal, and Andorra. And we provide audit, consulting, tax, legal, and outsourcing services to accompany our clients and Kreston clients in their daily business, international expansion, and growth. And how we do by providing them with the best advice and resources to support all the needs that they may have in the mentioned areas. Currently in Kreston Iberaudit, we have a multidisciplinary, proactive, and above all committed team of more than 300 professionals with extensive experience both nationally and internationally. So our efforts are aimed at offering a full service to the companies, a service of trust, which, as you know, is what Kreston means in ancient Greek. And that for all of us is a fundamental pillar, and that we like to apply in everything we do.
Thanks, Elena. It's very useful to understand how your firm is able to support our clients with any of their Spanish requirements and the services that you can offer. So, the specific purpose of today is to talk about a situation where a UK company either sends an employee to work in Spain or allows an employee to work remotely in Spain. This is something that we're seeing a lot more of at the moment, particularly with regards to Brexit and also with respect to employees wanting a better location to work at during the pandemic. Obviously, this is a very complicated area, so we can't go into too much detail today. And we would recommend that if you are having this sort of situation in your own company, that full advice is sought, and it should be sought whenever there is an international move. So we're going to look at the key considerations for employers with respect to allowing this type of move from a Spanish perspective today. So to get started, Elena, what would you say a UK company would initially need to consider with respect to sending an employee to work in Spain?
Okay, thank you, Adele, for the question. Well, first of all, I think that the UK company should consider if they want to have a permanent presence in Spain, and also if the company works or wants to work for the Spanish market and Spanish clients. This is the first thing to consider and to study deeply. The second matter is to analyze the country where the employee or the employees that the UK company will have in Spain, if these employees will be liable to taxes in Spain because they will be considered a tax residents in Spain. This is an important issue to analyze if the employees will be resident in Spain for tax purposes. In case that the answer to this second matter was yes, that the employees by working and living in Spain will be liable to Spanish taxes as a Spanish resident, as the third thing to consider will be from when, which will be the first year when this employees will be considered tax resident. This is important to take into account because the Spanish tax calendar doesn't match with the UK calendar. So there are tricky. It's a tricky issue, and it will need further analysis. The fourth issue to consider is also to analyze if the move of the employee is a temporary move, which we could say as a temporary move if it's not planned to last more than 24 months, or if it's a definitive move, or if the employee is planning to live permanently in Spain. This is also relevant. And the fifth point, as I think as Adele has said before, is that in any case, it's absolutely necessary to contact experts in UK and Spain to study the concrete case and to study all these matters mentioned before.
So hopefully we haven't lost anyone already with how complicated this actually is. But from your perspective, is there a difference in the approach if the employee is working remotely on UK or non-Spanish clients, rather than sending an employee to work there to build up a Spanish presence or client base?
Yes, absolutely. As I said before, this issue is very relevant, because if the employee will work to build a Spanish presence or a client base, there will be more reasons for the UK company to be deemed to have a permanent establishment in Spain. So it doesn't mean that because of doing this work of building a Spanish client base, the company will be deemed to have a permanent establishment, but it's a matter to study carefully, and especially in case that the UK company wanted to avoid this permanent establishment, it should be studied carefully the task that the employee could do or not, and also the powers that this employee could have. So it's very relevant.
Definitely, and that's a topic that is worthy of another 15-minute catch-up, to be fair. But just going back to the payroll point, at what point would a payroll obligation be created in Spain?
Okay, there are like three scenarios that would imply for the UK company to be liable to register for payroll purposes in Spain. The first one is if in case that the UK company had a permanent establishment in Spain. That's why I said before, it's so relevant to analyze the permanent establishment issue. So in case that the UK company had a permanent establishment in Spain, this company will be obliged to register for payroll purposes in Spain. The second scenario it will be in case that the UK company had some type of Spanish source income subject to taxation in Spain, and that the employee cost could be deductible to determine the taxable base of the mentioning cap. This is a theoretical scenario, because in practice, according to the double tax treaty between UK and Spain, there is not, this situation will not appear in practice, because the double tax treaty reserves taxation of this type of income to UK. So fortunately, in this case won't be applicable. It's a theoretical case which could be applicable for other foreign companies, but not for UK companies. And the third scenario that will imply that the UK company should register for payroll will be in case that the employee moves to Spain to work for a UK company, but there was not an agreement of relocation in place. Okay, if that was the case, because of the Brexit and the absence of specific reciprocal agreements between the Spanish and the UK social security, the UK company would be obliged to pay in Spain the quotation of the Spanish social security of this employee, and so to register for payroll purposes. However, in case that there was an agreement of relocation of the employee promoted by the company, the first 24 months, this registration could be avoided with the notification of to the UK Social Security and to the Spanish Social Security of this employee movement as a common expatriate.
Thank you. So that's really highlighting how important it is to understand the length of the assignment and what the employee is actually doing for the UK company as well. I frequently see questions from clients as to whether they'd be able to use subcontractors to simplify the procedure, so using another firm to engage with their Spanish workforce instead of having to do it directly. What's your viewpoint on this?
Well, it's a complex issue which affects residents, labor, and tax law. First of all, from the UK company perspective, it could be a simple way to avoid the Spanish labor compliance duties. No? So it could work theoretically. However, in the practice, it could be difficult for the employee to get a residence and work permit without the UK contract. Above all, the Spanish work permit. Therefore, if the UK employee doesn't have a Spanish work permit, he or she could not be hired by a Spanish subcontractor. No? It's important to remind that after Brexit, the UK nationals are treated as any other non-EU person. In that case, it could be really hard to obtain the Spanish work permit if this employee doesn't have a European Union nationality or strong family links in Spain, etc.
Excellent. So a lot to think about there as well with respect to work permits. Just moving on slightly, I also see quite a few questions from my clients about whether they're able to change the contractual relationship between them and the employee so that they're treating the employee as a self-employed individual instead. Is this possible from your point of view?
Well, first of all, I have to tell you that my answer to this question would be taking into account the Spanish labor law. No? Considering this, my answer to this proposal is that implies a high risk. If the basis of the relation will remain the same, so that means that the work tools provided by the company will remain provided by the company, the same retribution, same timetable, the lack of autonomy to decide, then this change to a self-employment agreement could be easily understood a fraud. Each case should be studied individually, no? Because it's a difficult issue. However, my general answer to this proposal would be that it's not advisable to do this.
Thank you. So you have to consider employment status in a similar way to what we do in the UK, which is quite good to know. So what can your firm do to support our clients in a potential move?
Okay, well, at Kreston Iberaudit, we have a transversal team that offers a quality global expatriation service and support. Our objective is to achieve the adaptation of the employee to Spain in this case, at all levels and in the shortest possible time. Specifically at Kreston Iberaudit, we have a specialized tax department that can help the employee and the company to carry out all the actions of design and development of remuneration policies, tax calculations and tax estimates. No? So we can take care of tax resident studies, analysis of double taxation treaty, personal income tax, non-resident income tax, wealth tax returns, etc. We also have a labor department for specific management in this area. So we also can cover the study of all the labor implications, the payroll management, work permit, etc. And also we are members of the Alliance of Espatlan, and we currently collaborate in Spain with a company, City Spain, member also of Espatlan, that can help the employee to settle completely by helping her or him with private procedures, no? Such as housing search for schools, driving license, domestic service assistance, vehicle registration, whatever they need, more like private needs. we can help. No, so as you can see, we provide a complete, we say like a 360-degree service of quality and confidence.
That's really good to know, actually, because a lot of those points, some of our clients would struggle with respect to finding housing in the right location. So it's really good to know you can advise in all those areas. What would your advice be for any UK company thinking about employing someone in Spain?
Well, I think as I have explained, no, I explained before, it's really complex for a foreign company to have employees in Spain. And my first advice is that they should contact a Spanish advisor and a UK advisor, and to have a proper advice taking into account labor, tax, and residence point of view.
Perfect. And just finally, for those companies who've actually found out that the employee has been working in Spain remotely after the event, and this does happen, unfortunately, what tips would you give them to think about on how to sort out the historic position with Spain?
Well, the reality is that unfortunately the decision of the employee to move to work in Spain without the authorization of the or the agreement of the employer of the UK company could have relevant consequences, as I have explained before. No, it would imply for the UK company to have to register for payroll purposes in Spain. So once the UK company realizes of this unfortunate situation, my tips would be first of all, confirm if that the UK company does not meet the requirements or conditions to be deemed to have a permanent establishment in Spain. Once this has been analyzed, and in case that the conclusion is that the UK company doesn't meet the criteria to be considered to have a permanent establishment in Spain, the second tip will be to confirm the employee medium-term plans. No, so in case the movement was temporary, so that's, as I said before, could be considered in case that this move was planned to last less than 24 months. It could be avoided the duties for registration in Spain if an expatriate agreement was signed and reported to the UK and Spanish Social Security. No? So my tip would be this, no? That in case that the UK company didn't have a permanent establishment in Spain and the move was temporary, or it's not clear if the move will be permanent or temporary, will be to do this, not to sign a common expatriate agreement, which will cover the liability of the UK company and the Spanish employee. And in case of longer stays, although the UK company didn't have a permanent establishment in Spain, or then the registration in Spain will be unavoidable. No? It will be necessary to register in Spain for labor purposes according to the current legislation. No? It's possible that, well, we all know that Brexit has been complicated and there were many issues to cover. No, so I think that it's possible that in the next year, no, it's agreed new legislation that can cover these situations more properly. No, but currently these are the what can be said and recommended.
Excellent. Thanks, Elena. I'm going to say a very big thank you for trying to explain very complex issues in a second language for a start. But as I'm sure all of our clients are aware as well, we're still waiting for legislation in the UK in respect of social security and international social security. So hopefully it's a case of watch this space and things will become a lot simpler. I think the main takeaway from today for our clients should be that if they are looking at an employee moving to Spain, they really need to be proactive and take advice at a very early stage. Obviously, today we've just been learning mainly about the Spanish implications for these types of moves, so it's important to remember that there are UK implications to consider as well. Blogs relating to the UK implications can be found on our Knowledge Hub, and please feel free to contact me if you do need any help in finding these. I just want to end with a really big thank you to Elena for her time today. If anyone does have any questions or they do have employees who are considering a move to Spain, please let me know or your Bishop Fleming advisor, and we can make sure we introduce you to Elena and her team in due course. Excellent. Thank you for attending. And again, Elena, a big thank you for today.
Thank you to you.